Thank you, David, and good afternoon, everyone. Thanks for joining us today. So we're going to be discussing low and mid-rise housing, or LMR as it's known, and some of the emerging issues that we're seeing in the Land and Environment Court following the introduction of these reforms. These changes introduced by the New South Wales Government are already reshaping residential development across New South Wales. And as practitioners, developers, assessing officers and consultants, we're all now working through how these reforms operate in practice. So today we want to focus on what the policy says, where the uncertainty lies, and what issues are likely to generate litigation. There's some pictures of us looking fresh-faced before we had all these court matters to deal with. As David said, we're working alongside Adam Seaton, dealing primarily in Class 1 of the Land and Environment Court, assisting our team and councils as well as developers across New South Wales. Before we get into the legal issues, it's helpful to revisit what we actually mean by LMR. Low-rise housing generally refers to the 1 to 2 story development, so things like dual occupancies, terraces and townhouses, whereas the mid-rise housing refers to apartment buildings in the 3 to 6 story range, as well as shop-top housing. So it's in this mid-rise housing area that we're seeing most of the litigation in court at the moment. These reforms were introduced through amendments to the State Environmental Planning Policy, SEP Housing 2021, which commenced in February 2025. Now, despite these reforms coming in well over a year ago now, there are very few published decisions of the court that follow a contested hearing, with most appeals being resolved through 34 agreements, where amendments are being made through the court process by developers, usually to reduce the height or the yield for the LMR development. So the purpose of these reforms was straightforward: increase housing supply by allowing more density in areas close to transport hubs and town centres. Now, at present, there are 171 designated LMR housing areas across New South Wales, and this is the map that shows most of them. But despite this, and probably not surprisingly, the majority of cases we're seeing in court are in local government areas where these units can sell for millions of dollars. Affordable housing, I'm not so sure. As you would know, the viewer identifies what it defines as the centre and then maps the residential zoned land within 800 metres walking distance of that centre. The maps are indicative only, and if you're dealing with sites on the edges of the LMR mapping, we certainly recommend having them tested for walking distance. We'll come back to that topic shortly.
Okay, so what does the LMR actually allow you to do? In some cases, the provisions are unlocking permissibility for forms of development in circumstances where they were not previously allowed, and in other cases, the LMR reforms simply facilitate uplifts in height and density for development which was otherwise previously permissible under the prevailing planning instruments. As we have up here on the screen, in a continuation of the reforms that commenced in mid-2024, in which dual occupancies were made permissible with consent in all R2 zones across the state. The LMR reforms continue to permit dual occupancies as well as semi-detached dwellings on all land to which the chapter applies. That is not just land that is within what we call an LMR housing area, and I'll turn to that more in a moment, but instead on all R2 zone land that isn't otherwise excluded from or excluded land under the LMR. In respect of attached dwellings and multi-dwelling housing, these forms of development are now permitted in the R2 zone on land to which the chapter applies in an LMR specific housing area. That is not all areas within the state. Previously, multi-dwelling housing was a land use typology that was only a mandatory permissible use in the R1 and R3 zones under the standard instrument, albeit that some councils may have allowed it in other zones as well. Perhaps most interestingly, residential flat buildings are now permitted with consent in R2 and R3 zones where the land is subject to the LMR provisions and in an LMR housing area. Previously subject to any council-specific provisions, residential flat buildings were permitted in the R1 and the R4 zones according to the standard instrument. Now, this change in particular potentially unlocks permissibility for residential flat buildings in large areas of land where the relevant LMR housing areas, in circumstances where the application of previous LEP controls may well not have permitted this type of building typology. Finally, just a note to say that the LMR doesn't actually change the circumstances in which you might be able to carry out shop-top housing developments, that being made up of two different land use typologies, but it does have provisions that confer certain uplifts in height and density for shop-top housing as well. You've heard me talk about things like multi-dwelling housing and residential flat buildings only being permitted in what is referred to as an LMR housing area. However, determining whether or not you're in or out of this kind of area and whether you're in the inner or outer rings of it is not always a straightforward exercise. There's a few key points to be made. Firstly, the starting point is that LMR housing areas are structured around either mapped town centres or railway, metro or light rail stations, and reference needs to be made to the town centres map that's published under the SEP or Schedule 11 of the SEP in order to understand where those areas exactly are. As Jisella mentioned, the state government's also released some kind of indicative mapping showing the lands that might be included within these LMR housing areas, but it does need to be approached with a degree of caution because those maps are indicative only and they're not formulated with a precise eye to the application of the statutory definitions that are at play and also the site-specific constraints. Secondly, the LMR housing areas are broken down into two rings, the outer ring and the inner ring. The outer area is the land that's within 800 metres walking distance of one of these town centres or stations, whilst the inner area is land that's within 400 metres walking distance. Identifying which of these two areas you fall into is as it says up on screen, quite critical as it affects the type and scale of development that you may be able to carry out. Thirdly, walking distance is a defined term under the SEP, and it also needs to be applied with close reference to the relevant factual scenario that you have at hand, and because it involves a level of qualitative consideration, it is sometimes open to dispute, and we'll talk more about that in a moment. And finally, just to note that there are some quite extensive general exclusions from the LMR reforms listed in section 164 of the SEP, and it's important to be across those because they do prevent you from being able to carry out LMR development on that type of land. Some examples include bushfire-prone land, heritage affected land, land that's subject to the probable maximum flood in certain areas, and so on. Now, walking distance. As I mentioned, this is really crucial in determining the application of the LMR provisions, particularly those relating to the developments of greater density that we're seeing under these reforms. It is a defined term under the housing SEP, and we've had the definition up there on screen. That is, means the shortest distance between 2 points measured along a route that may be safely walked by a pedestrian using, as far as reasonably practicable, public footpaths and pedestrian crossings. This definition might be familiar to some of you from the days of the previous SEP affordable rental housing, where the same definition had appeared in the context of determining whether or not land was within an accessible area for the purposes of facilitating boarding house developments. Now, Adam and I think we might have just run what might be the first contested, or if not one of the first contested matters, turning on the application of this definition in the LMR context. We're actually awaiting the court's judgment. It's only just been reserved, and so we await that with interest. But it seems that the currently accepted approach to this definition is that which was expressed by Commissioner Gray in a case called Bennett and Northern Beaches Council. Again, this was in the context of the former SEP, and what seems to be the position arising from that is that the definition is using plain English language, needs to be given its ordinary meaning without any glosses added to it, in particular about who the relevant pedestrian is, and sort of general subjective considerations about the type of the terrain that they might be travelling across on one of these walking routes. So according to this approach, the pedestrian is just an average person. Importantly, they're travelling on foot and without any physical impediments, and so it seems it does not matter whether or not the nominated path does not contain facilities that render it suitable for example, mothers that may be pushing a pram or a person in a wheelchair, or pathways that may not have things like consistent lighting across them. The contentious aspect of the matter that Adam and myself were dealing with recently essentially related to whether or not the relevant pathway could be safely walked by a pedestrian because it required you to cross a 4-lane regional road that had quite considerable traffic volumes, and it was also at a T-intersection with another road in order to arrive at the town centre in less than the 400 metres. And the other argument that we had was that it was also, we thought, reasonably practicable to, and actually indeed safer for the pedestrian to just go slightly further down the road to a signalised intersection that I think took them outside of the inner area by something like 20 or 30 metres. Now, we'll wait to see what the court has to say about that one, but I'll hand back to Jisella just to have a look at some of the specific development standards that are applying to these LMR developments and how councils might approach the task of trying to assess something that may look very different to the strategic planning that they've done for these areas in the past.
Not sure where I point it, but it's not happening. I don't know if the IT person sitting in the box up there can move it on to the next slide for me. Thank you. Okay, so for low-rise housing, there are new non-discretionary development standards which create a level of certainty for applicants. If a development complies with these standards, then consent authorities cannot refuse consent on the basis that stricter local controls should apply. And this is a significant shift from where we were. It limits the extent to which councils can rely on local planning controls to resist compliant development. But it also raises new interpretive questions around what standards are truly displaced and what local controls remain relevant. I'll just point out here that in relation to these the low-rise typologies, they have minimum lot size requirements and lot widths, and you'll see when we go to the next slide that those standards don't exist in relation to the higher densities. So the same principle applies to mid-rise housing, but the implications are often more significant because of the scale of development involved. Mid-rise developments raise more complex issues around bulk scale privacy, overshadowing, and compatibility with surrounding development. This is where the tensions between state policy and local character become most apparent, and this is where much of the legal debate is now focused. So I've highlighted where there are no minimum requirements, and you'll see as we go on how that affects some of the cases. So this is an example of a current case we have before the court that demonstrates how complex these assessments can become. Now, we're looking at a relatively narrow site here. It's just over 10 metres wide. The proposal contemplates up to 8 stories, so that's 6 stories in the zone. It's zoned R3, plus an additional 2 stories under the affordable rental housing bonus in the infill provisions. In terms of ADG setbacks, as we know, the provisions say that you need to consider the ADG and provide separation to adjoining properties, but the ADG also says separation isn't required for blank walls, so you'll find lots of blank walls here. And privacy is dealt with by screens or orienting the windows to the front and the rear of the site. Other notable features is that the existing development, as you can see, which is modelled, comprises of low-density dwelling houses, 1 to 2 stories, with some old walk-up RFBs. And it's opposite the R2 zone, so it's at a transition point adjoining a lower zone. So immediately we have key planning questions. How much weight should be given to the current character? How much weight should be given to the intended future character? And how far can built form intensity go under the LMR framework? These are precisely the kinds of issues ending up in contested proceedings. I've just heard a comment from the front row, what about shadows? Well, of course a building of this scale is going to cast a significant shadow, but isn't that anticipated by these LMR provisions? So when do those shadows become unacceptable? At what point? Because we have to accept there's going to be some level of shadowing by these buildings. So this is a current case we have, and relevantly, there are 4 other almost identical buildings currently in court with the same local government area within 1 kilometre of this site. So for councils, these are really important precedent-setting considerations because any approval will establish the character of these suburbs moving forward. Section 149 of the Housing SEP makes it clear that where the Apartment Design Guide addresses one of the matters that is listed at A to H on the screen, inconsistent DCP provisions have no effect. Section 178 of the Housing SEP further restricts what provisions the DCP can regulate, identifying that in relation to zones R3 and R4, there can be no controls that restrict the minimum lot size or the minimum lot width. You might recall from the earlier slide where I had highlighted there are no minimum standards under the Housing SEP for these aspects. What results from this is development applications of the kind I just showed you, with 8-storey buildings being proposed on 10-metre wide sites and no ability to control or introduce DCP controls to the contrary. But there are local provisions that can help. So what can DCPs cover? In our view, the most important control that a council should have in relation to LMR development is a setback control. Setbacks are very distinct from building separation controls, and they're aimed at achieving different objectives. The objectives of the building separation controls in the ADG are primarily focused on achieving privacy, and the separation that's required to be provided depends on the nature of the building and its relationship to the boundary. Therefore, lesser setbacks or building separation is required to be provided between non-habitable rooms as compared to bedrooms and the like. And it's important to note that the ADG, as I mentioned earlier, says that no building separation is necessary where building types incorporate blank party walls. Typically, this occurs along a main street or at podium levels within centres. That's how it was anticipated to apply, but applicants, developers, are relying on those provisions to say that they can provide significantly reduced building separation, and that complies. Reliance on separation provisions in the ADG to argue for appropriate building setbacks is a challenge that we're currently facing in our court appeals, particularly on these narrow sites, and for councils specifically who don't have strong setback controls. So I know that a number of local government areas have sought to introduce specific LMR provisions. Most of those have savings provisions, so unfortunately don't help with the cases that we're currently running, but will assist in the future. But many councils don't yet have specific controls that apply, and unfortunately the provisions they currently have for setbacks or the like aren't responding to these unique situations where they never anticipated a building of this scale on a size so small. So they're not really fit for purpose. We're trying to do our best with them, but certainly councils should be considering whether they have the ability to introduce stronger controls. And there are other aspects of development that DCPs can cover, including matters such as heritage significance, building materials and colours, streetscape character. That's a really important one. If council has controls about what is the character that it intends for the area in light of LMR, obviously not a character that says we want just single-storey dwellings, but acknowledging LMR, acknowledging the uplift and talking about what kind of character, what kind of rhythm of the street it wants to see, that's really helpful because we don't have to guess. And then the bulk and scale of buildings as well. So we ask all councils to review their DCPs, see how their controls can be improved in response to the issues that we're seeing and to the applications that they're receiving. And that would certainly assist developers too, who don't have to come to court and argue about, well, what is the desired future character of this area that is undergoing transition.
So many of the matters that we're starting to see come through as appeals are ones that rely on both the LMR and the affordable housing provisions of the Housing SEP. As many of you are no doubt aware, because these have been enforced for some time, the infill affordable housing provisions underwent significant reforms back in December 2023, at which time I think it's pretty fair to say that some fairly lucrative heightened FSR bonuses were implemented in exchange for the provision of a certain quantum of affordable housing as part of the development, on the proviso that it be used as such for a period of 15 years from the occupation of these developments. The types of developments that are subject to these provisions are those that include certain types of residential accommodation, and of course the accessible area considerations also factor in here. as well. Most commonly, though, we're seeing these forms of developments come through as residential flat buildings that as I say, use the LMR provisions plus the infill provisions to achieve what's essentially an 8-storey residential flat building, assuming that you're within the in area of the LMR provisions. The application of these bonuses is explained briefly on the screen through this graphic, but in summary, a minimum 10% affordable housing component, and that's again the amount of gross floor area that's used for affordable housing, entitles you to a sliding scale of height and FSR bonuses of up to 30% or of whatever is the maximum permissible height and FSR in the circumstances. It's relevant to note that the maximum permissible height and FSR are terms that are also defined under the SEP, and they include the height and the FSR that's permitted under the LMR provisions, amongst other things, and so that's why you see people essentially stacking the LMR and the affordable housing bonuses together. In real terms, for a residential flat building development that's carried out within an LMR in an area in zones R3 and R4, it has an affordable housing component of 15%. The development would be subject to bonus height and FSR amounting to 28.6 metres and a 2.86 to 1 floor space ratio. And now this is obviously quite considerable potentially where residential flat buildings were not permissible in the past, so specifically in the R3 zone. That may have been the case in certain council areas, or certainly otherwise they might have been subject to quite different height and FSR controls under the relevant local environmental plans. Whether or not a development is being carried out solely as an infill affordable housing project or as an LMR project with the infill bonuses stacked on top of it, the infill affordable housing provisions include different types of development standards and mandatory considerations when you compare them to what exists under the LMR provisions. So, for example, there's a series of what we call non-discretionary development standards in Section 19 of the SEP that deal with a variety of issues spanning from site areas, solar access, parking, internal areas, as well as a mandatory consideration of character that Jisella will speak to in a moment. And so these provisions are presenting a number of interesting considerations in the assessment of development applications that rely upon them, and in the framing of council's contentions in merits appeals that we're dealing with. An interesting example of this is specifically in the context of an infill affordable housing development. A question that kept arising for us was, or at least in acting for many councils as we do, was that whether or not the non-discretionary development standards in Section 19 of the SEP had ousted whatever visitor parking rates the council might have had in force in relation to one of these infill affordable residential flat buildings. So as you can see up on the screen, Section 19 subsections 2, E and F had merely specified what rates were to be met in relation to the dwellings that were to be used for affordable housing and the dwellings that were not. It actually said nothing about visitor parking explicitly, which otherwise, if you were just dealing with a typical residential flat building assessed under the ADG and DCP provisions, those visitor parking rates would have been dealt with by the relevant DCP or the ADG, depending on the circumstances of the case. We had the privilege of acting in a matter recently where this issue was clarified. It's a decision of Commissioner Dixon of the Land and Environment Court, and the case name is Cogra Investments No. 1. The citation's down there on the bottom right of the screen. So in that case, the Commissioner had found, despite Adam's best endeavours, that the parking non-discretionary development standards essentially had covered the field for parking provisions for these types of infill affordable housing developments, and so the consequence of that was that actually any other visitor parking requirements didn't need to be complied with, and this is particularly as a function of the operation of Section 4.15 subsection 2 of the Act, which is the provision regulating these non-discretionary development standards, and it fetters the consent authority's discretion to refuse an application, as Jisella said, where there's compliance with one of these standards. Now, interestingly, on 24th of April of this year, the non-discretionary development standard for car parking was actually deleted from Section 19 of the SEP. It's been relocated into a new provision, Section 22 capital A. Parking rates appear to be the same, but it now just appears to be a development standard as distinct from a non-discretionary development standard. It also still remains silent on the question of visitor parking. Another interesting thing to note is that we think subsection B seems to be the first specific statutory recognition of the Guide to Transport Impact Assessment, which, as many of you probably are aware, it was published back in November 2024. It's intended to be the successor to the long-standing Guide to Traffic Generating Development that dates back to 2002. The requirement to give consideration to the GTIA is interesting and potentially of some significance because it includes changes to the parking rates that were previously specified in the 2002 guide, particularly because it attributes different rates depending on whether you fall into particular categories of land based on your proximity to public transport. And so we'll have to wait and see how this one plays out in practice and understand that there's a savings provision that applies to it, so it wouldn't apply to any existing DAs. And I'll hand back over to Jisella to talk about character.
Okay, so if a developer is relying on affordable housing, then Chapter 2 specifically calls in a character test under Section 20, which is extracted on the screen. Now, that's not to say character is not always relevant. Of course it is. Often your zone objectives include a character consideration, and if not, then it is always able to be considered under 4.15. But this is interesting because it's suggesting that in order to access the bonus, you need to turn your mind specifically to whether or not the additional stories and FSR would be consistent with the character. So consent authorities still need to consider whether the development is compatible. And it distinguishes two areas. The first is with the current desirable elements, or for areas undergoing transition with the desired future character. And this is where many disputes arise. Developers are often arguing that the reforms signal a clear intent for greater density. Councils and objectors often argue that character still imposes meaningful constraints, and this is where the legal tension is sitting. This leads to an important question, and it's one we're dealing with in almost all of our LMR cases at the moment. If an area has been designated for LMR housing, does it automatically mean higher density development reflects the desired future character? Not necessarily. The designation strongly indicates the government intent for increased density, but that does not automatically override all character considerations. This balance is likely to be a major issue in the future court decisions, and we're expecting quite a few to come through for the end of the year. So this is some modelling that we received in support of what is the desired future character. The building in yellow is the subject site, and as you can see, the expectation that was put to the court is that all of these sites would redevelop to the maximum envelope possible under the LMR, with the affordable housing bonus sitting on top. It's difficult to deal with this. The counter-arguments, of course, that not all sites are appropriate to achieve their maximum possible envelopes due to unique constraints. Zone transitions, topography, existing surrounding development, heritage listings. And then there's, of course, the question about whether or not this sort of development is viable on all of these sites. Some of them are quite narrow, small. Others would require amalgamation. Many of the sites contain existing strata buildings with quite a number of strata apartments, and it calls into question whether or not it's likely that those sites would be redeveloped in the mid to long term. And so how do you then consider that in terms of character? I don't think there's a question that these are areas undergoing transition, but where are they heading to? And without any clear character statements in DCPs and the like, it's left to the developers and the council to argue it out in court, and that's currently what we're seeing.
Another interesting example of the interplay between the LMR and infill affordable housing provisions that we're seeing day to day at the moment is about the application of the number of stories development standards under the LMR chapter of the SEP in the context of these ones that are stacking the LMR and the infill bonuses. So section 175 subsection 2 is the relevant standard for a residential flat building in the LMR inner area in the R3 or R4 zone, and it says development consent must not be granted for development for the purposes of residential flat buildings with a building height of up to 22 metres unless the consent authority is satisfied that the building will have 6 stories or fewer. Unlike some of the other provisions we've been discussing, this one actually is just a development standard rather than a non-discretionary development standard. And so there's no, entering into the debate about whether or not a Clause 4.6 request is necessary in the context of a non-discretionary development standard, but specifically in the context of development that is stacking the LMR and the affordable housing provisions, a question is arising as to the consistency of this provision with what you might be allowed to do in terms of building height and density under the infill provisions. And as I was saying, the application of those provisions may potentially allow up to something like an additional 2 stories on top of your 6-storey LMR building. So on one view, the provision just maybe doesn't apply to this kind of development, as it presumably exceeds a height of 22 metres, and so you might read the provision as saying that it's therefore not a residential flat building with a building height of up to 22 metres, and so it simply doesn't apply. On the other hand, the alternative approach may be that the standard applies to land in an LMR inner area in the relevant zones, and it has to be varied by means of a Clause 4.6 request if you choose to take up the extra height and density under the infill provisions, albeit that in that context it may well be accepted that using the infill affordable housing provisions is a sufficient justification for the use of a Clause 4.6 variation. Now this is just, as far as we're aware, it's not something that's been specifically resolved or determined, but it's but one example of an interesting example of a case where there is this interplay between the LMR and the infill affordable housing provisions, and perhaps some clarity would be of assistance in that regard. That is everything from us. I don't know whether we have time for questions or not.
We have time for questions if anyone has any, or you can catch us in the lunch break. I think there's a microphone available if anyone has any. Yeah, Lawson? Yeah, sure. Yes, it certainly is. It's difficult, so obviously we have to have regard to some extent what the existing character is, and that's very much site dependent. So for example, if there are existing development that isn't likely in the short term to undergo transition, then that's likely that building is going to be part of at least the mid to long term character of that area. So having a look at how it responds, how any building responds to those sites that are not going to be amended, and then having a look at things like heritage overlays and any character of that area. Certainly other considerations are sort of like the rhythm of the streets, the sort of consistent setbacks from the front setback, how buildings are set back from the street, how are they set back from one another, and the relationship between built form in that area. But in the absence of any controls giving guidance, that's really where this argument's coming up, because if there's nothing that is identifying to developers, well, what is the desired future character in an LMR world? I mean, there's often hints at what the character is in a pre-LMR world, but now that these low density, I mean, even though they're zoned for high density, a lot of these areas have remained low density. And so I don't think it's arguable, I think it's accepted by councils that there's going to be transition, but to what is the challenge we're having. And I mean, the cases we're running is that this is not a likely outcome for a number of reasons. First of all, some of those sites, as you can see, are so narrow. How would you even get a basement? How would you get any parking on them? There's questions about feasibility, but likelihood. But is this the design? Is everyone going to uplift to the maximum? Probably not. And what we're finding through a lot of the cases is we're reaching agreement on a lesser built form than what is possible under LMR, having regard to constraints of the site and the relationship with other buildings. So what we're seeing is this is not playing out in reality. But it's really difficult in the absence of any direction. I think I gave a list earlier about what sorts of topics DCPs could deal with: materiality, bulk and scale. So that's where you go to look for guidance on character, as well as the ADG, and obviously there's the tree canopy guide as well, which is relevant to character in terms of what sort of landscaping character is sought to be achieved in these LMR areas. So you have to have regard to all of that. But it is difficult for developers and councils where there's little guidance and you put forward an application for a maximum building envelope, which is a compliant one. Not always, this one's not, but a lot of the time it is, and it's not until you get to the council that they say, look, that's beyond what we're prepared to accept. We'd want it pulled back without an understanding as to why, because it's not clear from the DCP provisions necessarily that a lesser height and FSR is desirable for these areas. So, but it all comes back to impacts as well. But as I said, in terms of overshadowing, where is that boundary? Where's that line of too much overshadowing and pulling it back?
And view loss.
And view loss. Yeah, we have quite a few view loss cases at the moment in terms of LMR, particularly in the LGAs where you have wonderful views like Mossman, and the LMR region, the LMR area is right down to the water areas. So you can get some beautiful buildings that will instantly have view loss impacts to anything around there because it's all lower density. It's a tough question, but I hope I've... I was going to say, I'm sure we haven't given any guidance in your minds, well, guidance I hope, but any clarification to anyone as to what the answer is. We don't have the answers, the court doesn't have the answers, we're all working through it. What we've gone through today are some of the issues and the tensions. Obviously there's a lot of LMR development that is being approved, that is going up, so it's not everywhere, but it's in these particularly difficult areas where there's tension between existing and desired future character. Yes?
Just a question around the walkability.
Mm.
And I don't know if I'm really down with some of the decisions that have come out of the court in relation to that, because in my mind, even if it's not particularly defined, walkability in my mind would be the majority of people being able, majority of different people and different types of people being able to use a safe footpath, you know, like the safest route and measuring that route. Not that one person who's physically fit can negotiate a path. So even though it doesn't necessarily define that, I can't see why that can't be argued, you know, and tested, because for me it undermines the logic behind a walkable path for pedestrians. And pedestrians is more than one type of pedestrian.
Look, I absolutely agree with you. I think from a you know, that's really a meritorious way of looking at the walking distance. But I think the legal difficulties that you'll run into with that is that this approach of just the general able-bodied pedestrian is unfortunately gaining some traction in the decisions that are looking at this. And so I suppose the response that I'd have to that is that in some regards it would now seem that that approach is flying in the face of what is becoming established authority, whether it's right or wrong in terms of the morality and so on of it, but that's the situation that we're seeing.
Stephen?
Hi, Jisella, Alicia. I've just got two questions. One is to do with desired future character and your comment about the influence of constraints on that. I'd be interested to get your thoughts on how you think we should be viewing desired future character as distinguished from achievable future character, which is desired is not the same as achievable, and there are plenty of examples where stratas have been amalgamated. So interested to see if there is a tension there. And the second question is to do with the hierarchy of EPIs. So a couple of the chapters in the housing set have objectives on what they're trying to achieve in terms of affordable housing and LMR. Would that not override a DCP desired future character statement? How do those tensions exist?
So starting in terms of what's the achievable character, that's certainly the argument that we're looking to run in most of these cases, that this, even if it is desired, which we say it's not, but even if it is desired, is it achievable? And that's specifically having regard to the site constraints and the viability. Most of the cases we're working with at the moment have, well, each case is unique, but they often have relationships, the site have relationships with heritage conservation areas or heritage items adjoining the site. And so in terms of what's achievable for that site without impacting on the heritage significance of the HCA or the item, the argument is that these higher densities are not achievable on those sites. Obviously, the mapping was done in a way that was fairly generic. They picked a town centre and went out. And so, and in fact, in the material that was published alongside and some of the explanations and the reading speeches, they indicated that those considerations would have to sit on top of this mapping. So they acknowledged that you would still need to meet the heritage considerations and wouldn't need to have an acceptable impact or no impact on the heritage significance of those items. So that was acknowledged by the state government. And so I think, and we haven't had a hearing on this, but I think it's a strong argument to say, even though the controls allow you to go to these heights and this FSR, that is a maximum only, and it is always subject to the other considerations. And it's not achievable in some cases for the reasons we set out in the case and some of the reasons we've discussed today. And then in terms of your second question about the objectives, obviously the objectives are relevant. They're not called, in terms of the aims of those sections, they're not called into task specifically. And the list that I gave you in section, I think it was 179, of that a DCP can't be inconsistent with the ADG provisions that are identified, and then it also identifies you can't deal with the site area and the minimum width. Those are the only things that they have nominated, and that list, in terms of the ADG, is an exhaustive list in the way it's written. It obviously also says you have to have regard to character under the affordable housing provisions under section 20. So I think in my view, there's a clear intention about what the LMR is trying to cover and what's outside of that. And what's outside of that, it leaves to council. And I think that if there were strong controls about those topics that are specifically excluded from LMR, that you would have a good argument to say that you have to have regard to those and apply those, and that drives what is the desired future character or the achievable character. Okay. I see another hand. Sorry, I can't see you. See you.
Yeah, look, so I'm not aware of any decided cases on this, but it is an idea that I have heard floated around. And I mean, I would have thought that if a developer was offering, as part of their application or perhaps as part of a condition of consent, to carry out certain improvements to the public domain to allow, for example, a safe pedestrian crossing at a particular point, I don't see why that couldn't be taken into account. I suspect the tension around that is that developers may not want to go to the cost of doing that if they can try to argue otherwise that it's a safe crossing in its existing format. But it is an interesting thought, certainly.
Not sure if we have time for anything else. No? Lunchtime. Okay, thank you everyone. But Alicia and I will be around, so please come and ask us questions if you have any more.